started now, just so that we keep on time. So good morning, everyone. Welcome to part one of a two-part webinar series about the new US cosmetic compliance requirements in the US, presented by Global Victoria in collaboration with Austrade. I'd first like to begin by acknowledging the traditional owners of our land that we're meeting today, the peoples of the Kulin Nations, and pay my respects to their elders past, present and emerging, and to all Aboriginal and Torres Strait Islanders here with us today. Now, I think I can see about 50 or so people online, so it's really fantastic to see so many of you online today. We've had a great turnout. Many of you I have met before, worked with you, and others I haven't had the pleasure of working with. In collaborating with Austrade on this session, we have the great opportunity to have fabulous brands from across Australia joining us, as well as our colleagues from various states, the state trade entities. So welcome one and all. For those of you who don't know me, my name is Lizzie Moffat, and I look after the beauty, wellness and personal care sector for Global Victoria, which is the state government of Victoria's trade agency. So like Austrade, trade agency, but for the state of Victoria. We have roughly, I think, 24 offices in priority markets globally, 4 of those offices in the US. So we really do quite a lot of work into the US. We have with us here today my colleague from Global Victoria's New York office, Mildred Ruiz-Leal, otherwise known as Millie, and my colleague also from Austrade's New York office, Anjali Jain, otherwise known as AJ, and most of you probably know Millie and AJ. And both of them look after the consumer goods sector for our respective trade agencies. I'll hand over to Millie and AJ shortly to say a few words, but I'd first like to also acknowledge our wonderful guest speaker for today, Angela Dish, cosmetic industry practice group leader at, and forgive me if I get this name a bit wrong, Amin Talati Wasserman. And Angela, you can correct me if need be. Angela's been kind enough to offer her time today to impart her knowledge about the US cosmetic compliance requirements as they're changing to the Modernization of Cosmetics Regulation Act of 2022, or MoCRA, and what these changes mean for your businesses. Many of you, I'm sure, are already exporting to the US and others planning to in the near future. Navigating the changes that MoCRA will bring can be confusing and, a bit of a minefield. So we're really lucky to have an industry expert with us today to help break down these changes. Angela's going to help us understand the steps needed to be compliant with facility registration, product listing, et cetera. And then in part 2 of this webinar series, Angela will guide us through how to use the new FDA submission portal. Don't forget to register for that part 2. It's being held on Thursday, the 26th of October at the same time, so 8:30 to 10. We'll share the link with you again after this session. We'll be taking questions or relevant questions throughout the presentation. We do want to make it somewhat interactive. So if you have questions, please use the Q&A function. Try and avoid using the chat function, just use the Q&A function. Millie, AJ and I will read through those questions and pose them to Angela as they come through. And you'll see also we're recording today's session, so we can share that with you afterwards, so you don't have to sort of madly take notes. You can watch it back. Now, we've got a lot ahead of us today, so without further ado, I'd like to hand over to Millie, Global Victoria's Trade Manager based out of the New York office. Thanks, Millie.
Oh, thank you, Lucy. Hello, everyone. I'll be brief. It's very nice to see so many familiar names. And I'm very excited to bring this webinar to you and to assist you in the US. So hopefully we'll be talking soon again. I'll hand it over to AJ.
Hey everyone, it's again great seeing so many some names and companies, and I think most of you are very familiar with what Austrade does. We assist companies such as yourself in expanding globally. We do everything from providing advice to making connections where we can and providing in-market support. And this is a perfect example of educating you all on the latest changes to FDA, just so you guys don't get in a pickle. So we hope to avoid that in the future. I'm just going to quickly introduce Angela. She has an amazing bio, but I'm just going to do a really short overview of her experience. Again, she's with Amin Talati Wasserman law firm, and she heads the cosmetics industry practice there. She assists both domestic and international companies in complying with regulatory requirements applicable to manufacturing, marketing, and distribution of cosmetics. She's also the chair of NSF's International Joint Committee on Organic Personal Care, and is the chair of NSF's International Joint Committee for Good Manufacturing Practices for over-the-counter drugs and for cosmetics. So she has a lot of experience. She's also a member of the International Independent Beauty Association, where she sits on the committees for education, technical, and regulatory. So I'm going to hand it over to Angela. And thank you again, Angela, for your time.
Absolutely. It's an absolute pleasure and honor to be able to present to all of you. Educating is really it's just one of my favorite things to do. So being invited to speak to all of you today is an absolute honor, and I really do appreciate being here. So I'm going to share my screen with a presentation materials. And so let's see, here we go. All right, Millie or AJ, if someone can just confirm that you can see that.
Yes, we can.
Yes.
Wonderful, wonderful. Okay, so we have a lot to cover today, so I'm just going to get right into it. But I will just kind of cover a little bit of my background. So my background, I started as a litigator and happened to work for a really big international law firm at the time. And we represented PCPC, which is a very large Personal Products Council, very large trade association here in the United States, as well as some very large international cosmetic companies. So from my very first week on the job as a barred attorney, I've been working with cosmetic companies. And through litigation, I thought, you know, if companies just had someone to really help them and review just some of the basics, they'd avoid a lot of the litigation that they get caught in. And so that's when I started early on in my career speaking to companies and to consumer or industry groups about regulatory requirements, about litigation issues and ways to avoid and mitigate risks. And so it really is a passion of mine to be able to share my knowledge with companies. So without further ado, why isn't this? It's not going. There we go. Okay, so first, kind of an overview. We're going to talk about U.S. enforcement stakeholders, just to make sure that everyone understands what the government bodies that enforce rules within the United States is. We're going to talk about cosmetics under U.S. law and how it differs just slightly from Australia. Then we're going to get into MoCRA. So MoCRA, we'll talk about the key definitions, facility registration, product listing, adverse event reporting, inspection and records access, recalls, and then also some of the anticipated rulemaking that's going to be going on over the next few years as a result of MoCRA. So first, regarding the stakeholders. So in the United States, we have both the federal level, over here, where you, as a country, as companies who are going to be exporting from your country and importing into the United States, your first really interaction is likely going to be Customs and Border Protection. And so at the border, Customs will inspect products, and if it doesn't comply with U.S. law, they have the right to hold it at the border. So we're not going to get into those rules today, but just to let you know that, you know, U.S. Customs and Border Protection is kind of that first government entity that maybe your product is going to come into contact with. And then we also have the Federal Trade Commission, and then the FDA. And then from a voluntary self-regulation aspect, in advertising, at least, we have the National Advertising Division, which is a part of the BBB national programs. And then we have states. And I'm not going to get into the state requirements and particulars today, because that'll be covered in the part 2 of the webinar. But we do have enforcement issues that arise by both state laws involving ingredient disclosures, restrictions, and reporting obligations, but also enforcement by state attorney generals and city district attorneys. And then, of course, we also have, unfortunately, here in the United States, some states are more litigious than others. And so we do have some private litigants that attempt to enforce some of the rules as well. So the FDA is primarily responsible for the labeling of cosmetics. However, if you refer to a website on your label, well, then even the website has to be compliant with the FDA rules. So they have primary jurisdiction over cosmetics. And under the Food, Drug, and Cosmetics Act, they do prohibit the marketing of cosmetics that are adulterated or misbranded, and either when they leave you or become adulterated and misbranded in the interstate commerce. Then the Federal Trade Commission, their authority is really over advertising, but that advertising could be anywhere. It could be considered on the label. It could be on the internet, radio, your catalogs. So it's any claims that you make about the product anywhere, including on that packaging. And so what the FTC enforces is they enforce laws against any unfair or deceptive acts or practices, both in advertising, and then they expect advertisers, to have competent and reliable scientific evidence in support of their claims. So again, this is also a topic that could be an entire hour-long webinar. So we're not getting into the details of it, but this is just a nice little brief overview so you understand the intersection, right? So who has the primary jurisdiction over cosmetics? Both, right? There's a liaison agreement between these two agencies. And so while FDA primarily takes responsible for labeling and FTC primarily takes responsible for advertising, in reality, they both kind of interact a bit, right? So the FDA is going to look at your advertising, even if it's not on the label, to determine whether the intended use of the product meets the U.S. law's requirements for it to be a cosmetic. And then the FTC may look at the claims on the label also to evaluate either whether or not it meets the claims are appropriate for the product's purported classification. Right. So there really is some interaction between these two agencies. Now, the applicable laws for cosmetics, we have the Federal Food, Drug, and Cosmetic Act that was originally enacted in 1938. And maybe you may have heard, MoCRA is the first real amendment of the Food, Drug, and Cosmetics Act to cosmetic requirements. So, that's why this is kind of a big deal, because the same set of laws for cosmetics have really been in place since 1938. And so now the federal government is deciding to, let's modernize it. So Section 602 of the FDCA does define the conditions under which cosmetics can be deemed misbranded. And then I'm providing you the link here because really the implementing regulations of the FDA are the ones where you get into the nitty-gritty of like labeling requirements, font size requirements, and so forth. So I provided you the link for that. And then under the FTC, we have the Federal Trade Commissions Act. These slides are going to be available to you, so I'm not going to read down the bullet points, right? But these are just kind of the general takeaways from the FTC Act as well. So what are cosmetics in the United States? So cosmetics are defined specifically as articles intended to be rubbed, poured, sprinkled, or sprayed on, introduced into, or otherwise applied to the human body or any part thereof for cleansing, beautifying, promoting attractiveness, or altering the appearance. And also any articles intended for use as a component of any such cosmetic, right? And then we have our drug definition. And I present this because there seems to be a bit of an overlap sometimes in cosmetic companies' marketing that can be kind of druggish, and that's where companies will get in trouble with the FDA. And so a drug is defined as any substance that is intended for the use of diagnosis, cure, mitigation, treatment, or prevention of disease. And I also bring this up because if you look at the difference between Australia and the United States, It's one key word that causes there to be a bit of a difference. So in Australia, it defines cosmetics as substances designed to be used on any external part of the body or inside the mouth to change its odor or appearance, cleanse it, keep it in good condition, or protect it. So the keep it in good condition actually may also be considered a bit of the therapeutic statement, but protect it. So under the United States, protect would be considered a therapeutic claim. So while sunscreens may not necessarily be a cosmetic, or maybe they are a cosmetic in Australia. I'm actually not super familiar with Australian law, so I apologize on that. But a sunscreen is a drug here in the United States, and it's considered an over-the-counter drug. Also, if there are claims that a product removes wrinkles, eliminates wrinkles, reverses sun damage, protects against sun damage, all of those would be considered therapeutic claims here in the United States that would cause the product to be considered a misbranded drug. So again, that was that could also be an hour-long webinar, so we're not going to go into more detail about it, but I just wanted to make you aware of it. Now, there can also be products that are both cosmetics and drugs. And this is important to understand because some of the provisions we'll talk about later in MoCRA do not necessarily apply to a manufacturer that makes purely cosmetic drug combination products. Okay, so this would be like a shampoo is considered a cosmetic, but an anti-dandruff shampoo is considered a drug and a cosmetic, right? Or toothpaste that don't contain active ingredients such as fluoride that just cleanse the teeth would be considered cosmetics here in the United States. But if it contains fluoride or the marketing includes claims that it prevents cavities, then that would be considered a drug, right? Or and then you can also have a toothpaste that contains fluoride, but then also makes some cosmetic type claims, and then it would be considered a drug and a cosmetic. So it can be a little tricky coming from a country that the definition for cosmetics is a bit broader. And so I do always highly recommend that you seek U.S. counsel or regulatory consultation before marketing new products here in the United States, just to make sure that that classification is correct and meets the U.S. law requirements. So now into what everyone has come in for, the Modernization of Cosmetics Regulation Act of 2022. Now, there's not a lot of legislative history that we can look to like for intent, because although the attempt to update the cosmetic rules here in the United States has been was introduced multiple times over the last decade, it would get into a committee and then it would sit and die. And that kind of happened this last year during our legislative season when the act was originally introduced. It went into a committee and then it just sat there. And I got to say, most people in the industry thought it was just going to die, just like the other, prior ones had died. And then a week before Christmas, someone, I assume it would have been the author of the act, slipped it into our omnibus bill, which is the budgetary bill for the next year. And this is like a 700-page bill. And so the Modernization of Cosmetics Regulation Act was slipped in somewhere in the 600s. I think it was like 647. And so it was quite a shock for many of us in the industry, right over like 2 or 3 days right before Christmas, believe it or not. So as a result, there wasn't a lot of debate on the like legislative floor regarding some of its provisions or the timeline that it was requiring for FDA to do things. So it is a pretty tight timeline, right? So it was just passed last December, and already by December 29th of this year, the requirements that go into effect are listed here: facility registration, product listing, adverse event record maintenance, and serious adverse event reporting to the FDA, professional use labeling, safety substantiation requirements, recall authority, records access, and then also the FDA is supposed to be proposing a rule regarding talc, all by December 29th, 2023. The other deadlines that will be coming up in around July 2024, the FDA is supposed to be announcing a proposed rule for fragrance allergen transparency. So this will be kind of similar to the EU's requirements, where fragrance allergens are going to be identified and then those allergens would have to be placed on the label. And then December 29th, 2024, so 2 years after enactment, we'll have some new cosmetic labeling requirements regarding, which we'll get into later. And then also FDA will be announcing a proposed rule for good manufacturing practices. And then by December 29th, 2025, there will be a report issued by the FDA regarding PFAS in cosmetics. And then also the good manufacturing practices rule should be finalized by December 29, 2025. So cosmetic product. So previously we had the definition for what a cosmetic is, but we didn't have this definition. The cosmetic product is a new definition introduced by MoCRA. And so it's defined as, it means a preparation of cosmetic ingredients with qualitative and quantitative set composition for use in a finished product. Oh, I am missing a slide. Where'd it go? Okay, well, anyways, so that some people have asked, okay, well, does that mean that if a manufacturer is just manufacturing, say, a mixture? Well, mixtures generally have a set qualitative, quantitative set composition, and they're ultimately going to be used in a finished product. However, the term ingredient includes both single compounds as well as mixtures. So arguably that should not be the case, that the mixture would not necessarily qualify a facility as being manufacturing a cosmetic product. However, that is something that I'm still waiting on some FDA guidance on and some responses to comments that have been submitted to FDA. So that is something that we'll be providing further clarification on in the next webinar, in the part 2. So what is the responsible person? Now, responsible person is probably a term you've heard before if you export products to the EU. However, in the United States under MoCRA, it has a bit of a different meaning. So the term responsible person means the manufacturer, packer, or distributor of the cosmetic product whose name appears on the label. And then label, under both the FD&C Act and the Fair Packaging and Labeling Act, means a written, printed, or graphic display of information on the container of the cosmetic or affixed to the packaging of the cosmetic. So this is a little bit different than in the EU, because under the EU's responsible person states that the responsible person is a legal or natural person based in the EU who will act as the unique representative for that product throughout the EU. So it doesn't necessarily have to be the manufacturer, the packer, or the distributor, right? It can be a third party that is just holding the product information file that confirms that the product information file that the cosmetic company provides them is accurate, and then they act as that point person for companies within the EU. That is not what the United States, that's not what MoCRA provides. So one, the manufacturer, the distributor, the packer is not necessarily a natural person, right? Unless maybe it's a sole proprietor selling the product as an individual. So it would most often, though, that's not the case. Usually a natural person, an individual would form some kind of company, right? A limited liability company or corporation, and then have that be the name on the product, right? Also, for the cosmetic product, the responsible person does not have to be located in the United States. There is no requirement under MoCRA's, the language of MoCRA, that the person have to be located within the United States. Now, we will talk about the fact that for facility registration, the facility, if it's a foreign facility, you do have to identify a U.S. agent that's located within the United States, but it's not a requirement just for the selling of products, of cosmetic products. So if you are only a distributor or packer of a, if you are only a distributor or the brand of the product and you are not the facility who's manufacturing, you do not have to have a U.S. agent. I just want to make sure that's clear because I get asked that question a lot. So what is a facility? So under MoCRA, a facility includes any establishment, including the establishment of an importer. So in other words, non-US domestic establishments that manufactures or processes cosmetic products distributed in the United States. So there's a couple terms that are important to understand. So first, the term manufacturer of a cosmetic means the making of any cosmetic product by chemical, physical, biological, or other procedures, including manipulation, sampling, testing, or control procedures. So even if you sold an oil, let's say it's an argan oil and you're selling it as 100% argan oil, but you're getting that in and you are physically, maybe you're filtering it, maybe you're testing it for purity, you're putting it in a bottle, right? That would still be considered processing, even if you're not combining that argan oil with other things. So, and now processing, the draft guidance that was just issued last month, it also said that manufacturing or processing means engaging in one or more steps in the making of any cosmetic product by chemical, physical, biological, or other procedures, including manipulation, sampling, testing, or control procedures. So it's very similar to what the regulatory language for what manufacturing meant. So facility does not include these things. I'm not going to read it all, but I want to point out that under this last bullet point right here, an establishment that solely performs one or more of the following with respect to cosmetic products is not considered a facility that would have to be registered. So that would be labeling, relabeling, packaging, repackaging, holding, distributing. Right. And also right within MoCRA, it provided a clarification. Oops, back up. That packaging and repackaging does not include filling a product container with a cosmetic product. Filling is considered more like processing. So if a company, if your machines are holding formulation, even if it's the finished formulation, and it's going through your machines in order to fill a container, that is arguably processing. We are still waiting for further guidance from the FDA to confirm that they are going to require facility registration for a facility that only does filling. But at this point, it does look, because of that clarification that was provided right within MoCRA, that filling would be considered processing that would require facility registration. I'm hoping to have further clarification on that by part 2 of this webinar. Okay, so there are some exemptions for companies that are small businesses. And so I want to put that right out front, what a small business is. So under MoCRA, a small business is the responsible person, owner, and operators of facilities and facilities with a gross annual sales over the last 3 years of less than $1 million, adjusted for inflation. And this is very important, who do not engage in the processing or manufacturing of cosmetics that include products that come into contact with the mucous membrane of the eye, that are injected, such as like tattoos, that are meant for internal use, such as like douches, mouthwashes, potentially, I think maybe potentially even ear cleansing products might fall under that, intended for internal use. That is also something that we're going to want to get clarification of from the FDA, or that alter the appearance for more than 24 hours. So if you have a product, let's say it's a hydrating cream, and you make some claim that it keeps you hydrated and plumped and causes the skin to look a certain way for 48 hours, does that fall within that? That's a good question. I don't have the answer for it right now until the FDA provides us some more guidance. Now, small businesses who qualify under this definition, they're exempt from both the GMPs under 607 or 606 section of MoCRA, as well as facility registration and product listing. So now let's talk, I'm going to do some hypotheticals. And if you would like to raise your hand and answer the question, you're more than welcome to. So let's say that company A manufactures, labels, and packages all at the same place. And company A also puts their name is on the label when it's distributed out to consumers. Who is the facility and who is the responsible person? What do you think? Is anyone raising their hand, AJ, or?
No one's
Angela.
raising their hand.
Nobody? Okay, well then I will just say, so company A is
Curtis
going to
is.
Oh, Curtis. Okay.
Oh.
Do we want to unmute Curtis so he can tell us?
Okay, give me a minute. Let me see. Curtis, where are you?
Oh, I
Yeah,
guess we have so many people. It might be difficult, huh?
There we go. Mic is on for Curtis.
All right, Curtis, what do you think?
Both, yeah. So
Yes.
company A is both the responsible person and has to have a registered facility.
That's right. Now, why don't you stay on the line and answer this next one? What if company B, who I didn't even mention in the hypothetical, what if their name is on the label? Who is the facility and who is the responsible person?
Oh, okay. Company B would be the responsible person, and A would be the registered manufacturer. So that's just like being a contract manufacturer.
Excellent. Thank you so much, Curtis. Okay, so hypothetical 2. Company A manufactures a lotion formula. Company B bottles and labels the lotion for final product. Company A's name is on the label. Company, and so who would be the facility? Anyone want to raise their hand? Alternatively, you can type it into the question and answer spot. Or maybe because we have so many people, I should just answer it.
Okay, we're dying to know.
Yeah. Okay, so in this situation, both company A and company B are arguably facilities, right? So they both have to register as facilities because company B, because of that distinction that MoCRA made about what packaging is considered, company B, if they're doing the filling into the bottles, then they arguably are processing and would have to register as a facility. So that's whether or not company A's name is on the label, or if company B's name is on the label. Both company A and company B are going to be the facility. Now, if company's A name is on the label, they would also be the responsible person. And if company B's name is on the label, they would be the responsible person. So it just kind of depends on whose name is on the label. Now,
and Angela, sorry, on
yes.
that, Sanaz Zahiri, 10 points because they popped in the chat there that both A and B are the facility.
Nice. All right. So hypothetical 3 is going to go back to number 1. However, manufacturer is a small business. So who is the facility and who is the responsible person? Give someone a moment to pop it into the Q&A. Da, 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 da.
We need some music.
I need some theme music, right? A game show theme music. Okay, well, in this situation, the manufacturer as a small business, as long as it's not manufacturing products that are meant for the mucous membrane, they're not injected and they're not internal, the manufacturer would not be considered a facility because or maybe they're a facility, but they'd be exempt from the requirements for facility registration and GMPs. Now, if the company whose name was on the label was not a small business, but the manufacturer was a small business, so the responsible person wasn't a small business, even though the manufacturer is, well, then that responsible person would still be required to list the products through the product listing, but the manufacturer would still not be required to register the facility. So that's a little bit of just a little trick. So company A manufactures and fills into bottles. Company B labels bottles and packages into outer container. It's private labeled for company C, which is a small business. Who's the facility and who's the responsible person responsible for product listing? Let's see if anyone pops it into the Q&A what the answer is. Okay.
Nothing as yet.
No? Okay. Well, in this situation, Company A is the facility that needs to register. Company B is not a facility that needs to register if that's all they do. If all they do is label bottles and pop them into packages, they're good. They don't need to register. Company C doesn't have to list because they're a small business. And in this hypothetical, we're assuming they are definitely qualified as a small business. So even though the manufacturer is having to do a facility registration and identifying specific things that are required, which we'll talk about in a little bit, Company C, as a small business, is not having to do the product listing. Okay. Now, hypothetical 5, Company A manufactures a mixture for algae extract. Company B uses the mixture in manufacturing a final formulation of a serum. Company C bottles that finished serum into bottles and labels it, and Company D's name is on the product as distributor. So in this situation, depending on how the FDA interprets that description regarding the filling, depending on how they interpret cosmetic product as to mixtures, like an algae extract, Company A could be a facility that needs to be registering, right? Company B is utilizing the mixture and combining it with a bunch of other stuff and is manufacturing the finished formulation. So they're definitely a facility that would need to register. Then Company C, who's bottling it, they may even need to register, right? Depending on how FDA interprets the filling part of this. And then Company D, as the distributor whose name is on the product, they are the responsible person. So A, B, C could potentially have to all register. And then Company D would be the one responsible for doing the product listing. Okay.
Angela, we do
Right.
we've got one more question in there
for
you, a hypothetical 6. What if there is dual manufacturer for a single product? From William. Thanks, William.
Right. And there might be, William, there might be. And what that would happen is both manufacturers would register, and they would identify what they are, the fact that they are doing the bottling or they're doing the mixture. They would have to say what brands that they actually process and what the category is. So yes, they would both have to register independently. Okay, so facility registration, getting into that. So who must register? So anyone who owns or operates a facility that manufactures or processes. There's only one registration that's required per facility, regardless of how many brands they contract with. Any existing facilities that were in existence prior to the enactment of MoCRA have to register no later than December 29th of this year. And then if you were a new facility that came about after the enactment of MoCRA, then you have 60 days after first manufacturing of cosmetic products. But no later than, so let's say you literally started manufacturing on December 28th, right, of 2023. Well, then the latest you can register would be that February 22nd date. So 60 days after the enforcement date. Okay. Now, facilities, once you do register as a facility, you have to re-register or update your registration biannually. So that means if you have any changes, to your registration, to the information. So maybe you're no longer manufacturing for a brand, you would update that information in your registration sooner, right? I'm sorry, I skipped ahead. So registrants must provide updates to registration within 60 days of any change to that information. So let's say the contact person that you put in your facility registration is no longer with the company. Well, within 60 days, you need to update that information with the FDA in the registration. Or let's say your address changed, or let's say you are no longer manufacturing shampoos and you had a list of shampoo companies that you manufactured for. Well, you would go in there and you would update that every 60 days. If there are 0 changes and it's just, then you have to, at a minimum, re-register biannually, so every 2 years, okay? And then failure to comply, so failure to register, is considered a prohibited act under the Food, Drug, and Cosmetics Act. So what is required to register? This is the bare bones. Yes.
Angela, quick
No
question.
problem.
So if someone was to not comply, what's the implication?
Well, the implication is that if a cosmetic brand was selling products manufactured at a facility that failed to register, then those would be considered unlawfully in the marketplace, and it could result in a recall. It could be result in being held at the border. It's considered a violation, and so any of the enforcement mechanisms that FDA has, they could impose against the brand. So, luckily though, if you utilize a third-party manufacturer, MoCRA actually gives the responsible person the opportunity to register a facility themselves. So you don't have to be the owner of the facility to register. So this is actually kind of a good thing. I know for a facility owner might go, wait, what? Somebody's going to put my name into the FDA's database without my approval? A responsible party, so a responsible person, so the brand, if they are using a third-party manufacturer and that third-party manufacturer has not done the registration themselves, then the brand can go ahead and do it. Because the information that's needed is not particularly onerous, right? This is all that's needed. The facility's name, physical address, an email address, and a phone number. A facility registration number if they were previously assigned one. And if the facility is located outside the US, the contact information for the US agent. So having a US agent is not particularly difficult. We're going to talk about that today. So I won't go into it now. But so even if a facility doesn't register, what the brand would do to make sure that their products don't get stopped at the border, that they aren't subject to impound or recall orders or warning letters, is they would register that facility themselves.
And Angela, we do have one more question for you, actually,
yes.
From Curtis. What about importers? The overseas manufacturer needs to register and the brand or distributor is the responsible person? ? So what's the implication for importers?
Well, when you say importer, do you mean the company whose name is on the product is distributing the product? That would be the responsible person.
Okay.
So if you're just an importer acting as like a broker and you're just helping getting product across across the border, but you're not actually responsible for getting it into retail stores or responding to consumers or anything like that, right? Your name is not on the product and you're not processing the formulations. And you are literally just the company who transports it from this country to that that doesn't require registration. That would not be considered a facility.
Okay.
You would have
Curtis,
to. Go ahead.
I was just going to say, Curtis, has that answered your question?
Yeah, that does. So the only so you don't even need a GMP certification to actually to register your products with the FDA. You don't need to show GMP compliance in any way.
Sorry, there's a bit of background noise on your mic, Curtis.
Sorry.
Maybe just type, if you could type the question and then I can get back to it.
Great, thank you.
Great. Okay, so what is a U.S. agent? Now, there is, under MoCRA, they did not define specifically what the U.S. agent is. However, U.S. agent requirements have existed for many years in other sectors within the FDA industry, so food, pharmaceuticals, and medical devices. So even though we don't have specific guidance as to cosmetic U.S. agents right now, we can look to those other regimes to determine what are the expectations. So the basics are, one, it's a legal entity or a natural person physically located in the United States. They generally are not allowed to be a post office box or an answering service. And the person has to just be authorized by the foreign manufacturer or processor to act on their behalf when it comes to communications to and from the FDA. So, for example, in the medical device context, these are the responsibilities for the U.S. agent. They assist with FDA communications with the foreign establishment. That way, the FDA can just send a domestic letter, right? Or make a domestic phone call to the identified U.S. agent, who can then help communicate that information with the foreign establishment. They'll respond to questions regarding the foreign establishment's devices that are imported. And that would be like, and obviously any of this information that the U.S. agent is getting, they're getting it from that device manufacturer. So they'll help assist FDA with scheduling inspections of foreign establishments. And then if the FDA is unable to contact the foreign establishment directly and quickly, then FDA may provide information and say documents or requirements directly to the U.S. agent, and so that the U.S. agent then has to get that information to the foreign establishment. So this is a bit different than, say, the responsible person requirements like in the EU, right? And I have seen some regulatory consulting groups describing this as a little bit more extensive of what is required. But really, U.S. agent is really more like just a communicator, right? It's a point of communication, domestic communicator for the foreign establishment. So what is another question that often comes up is, in that facility registration, there was a requirement, and even in the product listings, there is a requirement that the FEI, or the FDA established identifier or form established identifier, be provided. And so when you see that, if you're wondering what that is, this is how you figure out, well, do I already have an FEI and I don't even realize it? Because sometimes that can happen. If you've had any communications or issues with the FDA may have already assigned you one without maybe even you realizing it. So to determine one, I've provided the steps here. It's pretty easy to walk through to figure it out. And then if you determine, okay, well, I need an FEI because I'm a facility and I'm going to have to register, but you are not within that portal, you can then email this address here, feiportal@fda.hhs.gov, with this information, and they will provide you an FEI. And FEI requests generally take about 8 to 15 days. So if you are a facility and you don't know if you have an FEI number yet, I suggest going through those steps to figure it out. And if you don't have it, do this request sooner rather than later, because trust me, as we're getting closer to the deadline, they're going to be inundated with requests, and the response time could end up being slower. Okay, so
sorry, Angela.
Yeah,
sorry, it's Lizzie here. We've got a few questions that have come through regarding facilities. Are you happy if I read those out to you now and you can address some of those?
Sure.
So from Celestine, what if the facility doesn't know that the brand is selling into the US? Is the facility in any way liable? So a facility in Australia, if they don't know that a brand they're manufacturing for is selling into the US.
So ultimately, if a brand is selling into the US and they haven't even told their facility that they're selling into the United States, to even give them a heads up that they need to do this registration, then the brand should be doing the facility registration for them. Because it's the brand, once that product enters into the marketplace, it's the brand that's ultimately going to be responsible for failure of not having their product manufactured at a facility that's registered with the FDA.
Okay, so the facility will not be liable in that case. Well,
what's the FDA going to do? You're a foreign entity. You had no idea you were selling into the United States. I mean, what are they going to do? Suspend your registration that you don't even currently have, right?
Yeah, fair call. Okay. And another question. Oh, sorry.
I was just going to say, it's just the brand, though. The brand would get in trouble.
Okay, yeah. Another question here from Judy. If third-party contract manufacturing facility is outside the US, e.g. in Australia, would the brand be the agent? And then a follow-on from these, can the agent be an FDA attorney, which we already have?
Okay, so the brand So the brand's located in the United States, but the facility is located in Australia. Is that what I'm hearing?
I would say brand located in Australia, but let me just find Judy here, and
Well,
Judy,
here, I'll
okay.
I'll give both answers.
Okay.
So if the facility said, "Hey, brand, you're the only brand, that's distributing our products in the United States. You're located in the United States. How about you act as our U.S. agent?" And the brand agrees to that. You just want to make sure that that's understood and that you have something in writing agreeing to act as that U.S. agent. Right. If it is both a foreign brand and a foreign facility, yes, I actually act as U.S. agent for clients. Our firm acts as U.S. agent for clients, for clients, right? And it's only, I don't know, it's like $350 a year. It's not, it's really not that expensive, and it doesn't require all that much work. It's not that often that companies are getting communications directly from the FDA unless something arises.
Yeah.
So yes, you could, if you have a U.S. FDA attorney, you could ask them if they would be your U.S. agent. I don't know. I don't think all firms provide that as a service, but given our particular specialty within that FDA sector, because I mean that's our entire what we do. We are FDA focused. That's why we act as a U.S. agent for our clients.
Okay.
So,
We'll
yeah.
do one more question and then we might keep moving. There are a few in there, but I want to make sure that we cover everything here.
Yeah.
So from David, is the small business exemption for the brand or for the manufacturer? I.e., if brand offer both?
Yeah, it's for both. So if the manufacturer is a small business, they don't have to register their facility and they're not subject to GMPs. If the responsible party, the brand, is a small business, they're not responsible for having to do product listings.
Okay, great. I think we might keep moving and we'll
yeah. So there is a distinction when it comes to facilities. So there's that, remember we talked earlier about that drug cosmetic distinction, and sometimes you can have combination drugs. So this is Juice Beauty, for example. This is a CC cream that you see here. It has some SPF claims on it, which may be difficult for you to see, but it says broad spectrum SPF 30. But then it's also a CC cream, so it's providing tinting, and they market it as, helping skin look smooth and so forth. I happen to be wearing it today. So if a facility only makes drug cosmetic combination products, so maybe it's a sunscreen or it's like the CC cream, they only make those kind of combination things, or they only make those combination products and then pure sunscreens, right? Or other OTC drugs. Well, then they're not subject to the requirements in MoCRA. Instead, they would be subject to the requirements under Chapter 5 of the FDCA, which is applicable to drugs, right? So, but if a facility makes these combination products on, some of their lines, but then they also make purely cosmetics that don't make drug claims that are not also drugs. So you have both lines that make these combination products and lines that make just cosmetics. Well, then those lines that make the combination products would be subject to the drug rules and not MoCRA, but the cosmetic lines would be subject to MoCRA, and you would be required to do the facility registration and the product listing and so forth. So there is that distinction that the facilities need to understand. I know it's a little complicated, but yeah. All right, so we're going to really need to kind of speed up here. So FDA suspension. So FDA may suspend a facility's registration if they determine that there's reasonable probability that that the products that are being distributed in the U.S. There's reasonable probability for causing serious adverse health consequences or death, and also. And if the FDA has reasonable belief that the products manufactured or processed in the facility would be similarly affected as to other products, right? Because the issue is so pervasive. And then the effect of the suspension is that if the registered facility is suspended, then the brands who use that facility must stop. They can no longer introduce products into stream of commerce, right? So this is very important to understand because, ultimately the brand who is distributing could end up in trouble, even if they're not the, responsible for the facility, bad acts. So now facilities are provided certain notice requirement, like certain notice and certain opportunities to cure. That's not, it's a little bit more detailed. So I'm not going to go into it today because we are covering so much. But if it is a topic that you guys would like, covered in the next part, please let, AJ or Millie or Elizabeth know, and I can incorporate a little bit more detailed slides into the next presentation. All right. Product listing. So now we're talking about the responsible person. So product listings must also be submitted by the end of this year, December 23rd. And then new products in the marketplace have 120 days. So if you remember facility registration, it was 60 days. Product listing, it's 120 days. Updates to product listing may be done on an annual basis rather than within that 60 days, like what was for facilities. Instead, updates can be annual. So maybe product name changes or formulation changes, so ingredient changes, those would not have to be updated immediately. It would be updated annually. Also, a single product listing is supposed to suffice, where products are sold in just, different colors or flavors or quantity of contents.